Hello, everyone. I'm Peter Saunders, editor of Canadian Consulting Engineer and host for today's webinar, Risk Management and the Economic Value of Copyright Licensing, sponsored by Access Copyright. In a world where a published article or industry standard can be shared with the click of a mouse, organizations struggle to manage their risks around copyright infringement while also enabling collaboration and knowledge sharing. As each publisher has its own restrictions on reuse, risk managers face the challenge of complying with a wide variety of terms and conditions. In addition, as more organizations cut back or even eliminate their internal libraries, employees lack guidance on how to share and distribute digital content within the bounds of copyright laws. Through strategic licensing of content in addition to their traditional subscriptions, engineering organizations can reduce risk and administrative costs and collaborate strategically with others both within and outside their enterprise. Today's webinar will address how licensing content can increase its value to the organization, why protecting the organization from the risk of copyright infringement matters in the digital age, how copyright licenses benefit the enterprise in terms of streamlined access and risk mitigation. Our speaker today is Mary Ellen Bates, principal of Bates Information Services based in Colorado. She provides business research and analysis to strategic decision makers and consulting services to the information industry. She's a prolific writer and international speaker. Prior to starting her business in 1991, she worked in specialized libraries for more than a decade. But before we begin, I have a few housekeeping notes. During today's live webinar, you'll be able to submit your questions by using the Q&A button at the bottom of your Zoom panel. We will then get them answered at the end of the presentation. Also, please note you'll be receiving a video recording of today's webinar within about 24 hours after we wrap up. And now I'm going to hand things over to our presenter. Take it away, Mary Ellen.
Thank you so much, Peter. And one other thing about my background that I guess I need to disclose, that I am not a lawyer. So all of what I'm talking about today is from my experience as having worked in the information field for decades and having worked in collaboration with Access Copyright to pull together this workshop. So if there's ever any doubt, my first advice is to talk to your legal counsel for clarification. So the three general areas that I'll be covering today: first, some copyright basics, because copyright includes more than what a lot of people may assume it includes. I'll talk about managing copyright risks, especially in today's kind of strange world in terms of what exists in a form that can be copyrighted. And then I'll talk a bit about the strategic value of copyright licensing specifically. So first, looking at copyright basics, what is copyright? It's essentially, it's the protection of a creator's of creators' intellectual property that exists in any fixed format. So that can include a lot. Traditionally, we think of it as books and articles and journals and that sort of thing that's come from a publisher. For example, self-published materials are also included. Standards are included. Conference proceedings, which again is something that some people may not assume is inherently copyrighted by the nature of being in a fixed form, etc. There are some exceptions for work that's done as an employee, and as I've noted in this slide, and I will remind you throughout, when in doubt, check with your legal counsel. What's really interesting is in a lot of the material and guidance that you'll see about how to comply with copyright, a lot of the advice relies on court cases and the interpretation of those cases. So again, that's why if you have any specific questions, it's a good idea to talk to a lawyer. In general, copyright holder, the entity that created and owns the content that you're considering, that person or entity gets to decide what the terms and conditions of anybody else using that material are. So if I write a book, I can decide that no one is allowed to digitize it, for example, that it's only allowed to be reproduced in a published form in this way. Now, that would be kind of crazy for me to do, but as the copyright holder, I get to determine what happens to my material. For copyright, when it's a personal author that owns the copyright, the protection lasts a long time. It's the author's lifetime plus 70 years. And the important thing to keep in mind is that even if something is published and it's out there on the web, for example, you still have to get permission from the person who owns the copyright in order to share that material, to print it and distribute it, to save it on your intranet, to do anything with it, because they still own the rights to tell you what you can and cannot do with that material. Again, even if you find it on the web for free, it's still covered by copyright, what you can do with that material. And this is in a world where a right mouse click will let you copy anything and paste it into anything else. It's sometimes hard to remember that there are legal, restrictions there in what we can do. And this is sort of the big takeaway that I think is really important, is that just because you have a subscription to a publication, even if you have a subscription to the digital version of it, so you're getting it electronically, just because you have that, it doesn't mean necessarily that you're allowed to take one of the articles that say, if you've got a digital subscription, it pops up in your email box and you've got a copy there, you can't necessarily forward that copy onto a colleague, even in the same organization. You can't necessarily save it in your intranet, save it anywhere in storage, nor can you, even if you had it yourself and you relied on it to make a claim in a proposal or to cite a particular standard, for example, you're not allowed to forward that copy onto the client without getting specific permission. So again, even though you have a subscription to the content, all that entitles you to is that copy that you were given. Excuse me. So this is, and I will mention again that my background is as a librarian, and so many librarians that work within organizations, one of the parts of their job is making sure that not only they're managing the subscriptions that are being acquired for that organization, but also that all of the users of that information understand what's involved for them to forward that onto someone else. So what's generally involved is if you find an article, for example, that you think is pertinent and needs to go to a team that you're collaborating with, for example, on a project, and this seems like this is right on point, they should see it as well. So if you have a subscription to the periodical that the article came from, that's great. So you look at the terms and conditions of your subscription. That will be somewhere that is something that you signed along the line, or you can probably find it on the publisher's website. And you see whether in general they allow any redistribution of articles, or whether the copy that you have is not authorized to be sent to anyone else. So you'll check their terms and conditions and see whether redistribution in any form is allowed. If it is, then you'll need to reach out to that publisher and find out specifically whether you can be given permission to, for example, forward this article to the 5 other people on your project team. And if so, what's the cost to send those additional copies to the other people on your team? And then when you find out what it is, then you pay them the money, and then you get the license to send the 5 copies. So that's hardly a spontaneous way of getting the information out there. If you don't have a subscription, then you need to say you found an article that was on the web. You need to find out who created that article and who owns the rights to it. Contact them, do the same process, find out whether they will grant you permission to distribute the 5 copies, and if so, what they charge, and if so, how do you send them the payment so that you're licensed to make the copies. And once you've sent those copies, you need to make sure, of course, that the recipients don't send copies of that copy to anyone else because you didn't get permission to send that on to someone else. So it's a lot of steps involved there to make sure that you're complying with copyright when you get a copy of an article and you want to share it with your group. The alternative to all of that time and administrative burden is to use annual copyright licenses that you can then be assured that, for example, if there's a key periodical or publication that you subscribe to, and you know that you're likely to be sending those articles on to someone else, you get an annual license that allows you to do these specific things, to share it within a group internally, to share it to other subscribers, to save it on your intranet, whatever it is that would be useful for you. So that, I think, is the most important thing to keep in mind, is that the steps involved in complying with copyright involve a lot of administrative steps if you don't have copyright licenses. So when do you need to do all those steps to make sure that you're cleared, and that if there's a fee for redistribution, that you've paid the fee? And this involves pretty much anything that reproduces what it is that you've got, or that sends it to someone else. So if you have a document and you scan it and send it to someone else, that is a reproduction. You need to get permission to do that. If you find an article, if you subscribe to a publication, for example, you see an article there that perhaps you authored and you want to share it with other people when you're speaking at a conference, even though you wrote the article, you still need to get permission from the publisher to be able to make those, 100, 150 copies that you're going to be leaving at the tables at a conference, for example. Or if you've paid for a standard that you're using in a project and you want to save it within your intranet for anyone else to be able to use later, that you need to get permission for, because that's more than the one use that you purchased it for. If you're planning on circulating an article to anyone outside your organization or even within your organization, that needs permission, because again, it's more than you, it's more than your use for your own personal use. If you're at a sales meeting and you have copies of articles that you've written and have been published somewhere, or that are pertinent to the project that you're discussing, again, even though you had a copy that you subscribed to give a copy to a prospective client, you need to get clearance for. All this to say, there's just about anything that you do with content that you did not yourself create needs to be gotten permission for it. That's the sort of real basic takeaway on copyright in general. As a corporate librarian, I worked within organizations, and I would have this conversation all the time, and people would come up to me and say, but we already subscribe to it. So of course, can you just figure out how we can how you can distribute this copy to this list of 100 people? And, my head would explode having to explain to them that unless otherwise specified, you have to assume that any subscription, even a digital subscription, does not include the right to do anything with it but read it yourself. So anytime that anything that you get, you're sharing with someone else, you probably need to get permission for, unless you've already negotiated a license with that publisher that gives you specific permission to do any of those things. And the other, that's sort of the shaking your finger and being stern and saying, this is what you're not allowed to do this and that. But I think the other important consideration, frankly, is your organization creates deliverables, and that's valuable content as well. You protect your own intellectual property when you have marketing material, when you paid to get a design for a logo, all that is, that is your intellectual property, and you want to make sure that that's protected. Likewise, you want to make sure that you respect the innovation and intellectual property of others. So it's not only the law, it's also a good idea. The other question that always came up for me when I was working in corporate libraries, and when I do consulting work now for digital publishers all the time, is the whole argument of, but I found it on the web. So since anybody can get to it, surely I can redistribute it within my organization. And yes, you can, but just because you can doesn't mean you should. The things to keep in mind, and this is especially if you're looking for a copy of, say, an article, and maybe you find that it's available from the publisher for, $45 or $50, because that's what they charge for a single article. And you think, well, maybe I can find it somewhere else on the web for free. And the problem with that, and I run into this when I'm responsible for finding authoritative copies of articles for government filings for some of my clients, where they have to be able to justify something, and they have to have the version that they pay for, because what I find on the web, it may be a draft version and isn't labeled that way, or a preprint that hasn't been peer reviewed yet. It may be, if you're looking for a standard, you may find it on the web for free, but you don't know if it's been outdated. This is something that is often difficult to catch, but there may be older material that had to be scanned and then OCR'd into a digital text. And while it looks nice and formatted on the screen, often numbers and some words will get mangled in that scanning process, and you can't identify that from just looking at it. So you can't often tell whether that is the original or something that may include OCR errors. Anything that you find on the web, you may not know that that's the most current version. So if there have been corrections or retractions, they may not show up on some random web-based version of the article. Often when you're looking at peer-reviewed articles, the text of the article may appear somewhere else, but all of the graphics, the underlying data sets, and other important information may be lacking. And as a corporate librarian, as a former corporate librarian, the thing that would drive me crazy the most is that if you find it on the web for free, you'll have a nice URL for it, and it may just disappear one day, and you have no control over that. So relying on something that you find on the web, rather than getting a licensed version of it, makes you run the risk of having an inaccurate version and not even knowing it, because it looks current on the when you find it on the web, but without kind of knowing the provenance of it, you're not sure whether this is the accurate, most current, and a licensed version that you're available to distribute. Okay. There's a company called Outsell, and they look at sort of the information industry generally. And every year they do a report, or they do a study on information seeking and consumption. And so they put out the reports, the results of their study. And it's really interesting what they found. They look at various kinds of businesses to figure out what's going on. So what they found that I think is sort of interesting, one of the effects of the pandemic and the push for so much more remote work is that people share documents electronically much more. Partly they have to, because everybody is working remotely, and even when we're starting to come back in the office, or we have hybrid work settings, they've found that people that don't work in the same office tend to share a lot more. So if your organization has remote workers as well as people working physically in the building, keep that in the back of your mind as just the more that workers are accustomed to sharing information, the more likely they are to be sharing information that's under copyright protection. So just factor that in your risk evaluation. What this Outsell study found for the 2022, when it was complete, when it was done, is that workers, excuse me, workers in general are sharing electronic content 8 times a week with 15 other people, and half of that is external. So that's a lot of pieces of information that's going out to other people. What's interesting is that consulting and professional firms are even higher in this sharing. So here's the number. This again is extracted from the Outsell report. When you calculate the average number of times a worker in the professional consulting and professional services, each time one of those employees shares something, they tend to share it with 15 other people, and they do that 8 times a week. So they wound up in total, and of those, half of those are external people. So that's even more at risk in terms of sharing content that you may not be authorized to share. What that's telling you is that in professional and consulting firms, there's potentially 77 pieces of information being shared outside your organization that may not have been licensed if you don't already have licenses for redistribution. So that's a big number. When you're just looking at the potential of getting in trouble for something like this, it's surprisingly common that potentially unlicensed material is going out. This was a really interesting quote that the Outsell report found. Again, when they were talking about how they asked executives how many of them thought that it was important to make sure that the copyright laws were complied with, and that they used that they made sure that their material is licensed. And I think it was 95% said yes. But then when they were asked if they would share any relevant information to help their organization in an important situation, 90% said they would. So it was the sense there was that it didn't matter whether it was licensed or not. If it really mattered, they were going to send that material out. What that means is potentially there, and this is just looking at executives because they tend to share more information, there's the possibility of executives sharing 125 pieces of unauthorized information in a week. So these are just big numbers in terms of how likely it is that in any organization, material that is covered by copyright is likely, just in the course of business and how information flows, that this information will tend to get shared. And there isn't an automatic way that it's stopped from being shared, even if it's not licensed. And those numbers, the likelihood of those of unlicensed material going out is fairly high, just looking at the numbers that Outsell has found. On top of that, we're seeing a lot of, let's say, things are in flux. And understanding the role of copyright in the new digital age, for one of the biggest challenges right now that has both copyright lawyers and librarians pulling their hair out is ChatGPT, other generative AI tools, and the search bots that some search engines are coming up with, where they can they scrape material from websites and turn it into what looks like plausible text. And it's extracted from and kind of based on what it's found. But the question is, if material is pulled straight from another website and put into a ChatGPT answer, for example, without attribution or permission, does that violate copyright? We don't know yet. What if, now there's a sort of the equivalent of ChatGPT in the visual world is DALL-E, which you can give it a prompt and ask it to draw a panda on ice skates on the moon, and it can generate a lovely image of that. And the question there is, who owns that image? You as the person who designed the prompt that created it, or the company that is creating it, which isn't charging you for it, it's just generating these? What if the image that was generated includes your organization's logo, but it was recreated by an AI? How could you sue an AI for copy? So you can see how these have completely not been resolved. As far as I know, nothing's been taken to court anywhere yet, but I think this is an entire area in which understanding copyright will be very important if you ever start using these kinds of tools. Another thing that's making all of the applicability of copyright on the web problematic is Internet Archive, which is a giant archive of past copies of an existing website. And a while ago, they scanned a number of books and lent them out, saying they were just like a public library. It was at the beginning of COVID when no one could go to the library. And so this was a public good, and they were, they weren't selling the book. The initial court case that's in the US, they lost that case. It's being appealed. But the question is, can one organization scan material and make it available for free to someone else? Do they have a right to do that? It's sounding like maybe not. So all this to say is that copyright is being looked at in new and unpredictable ways these days. So it's a wild world out there. And I guess that leads me directly into why use a licensing organization, because there's a lot that is required to comply with copyright. Part of it is being mindful of the fact that if you didn't create it yourself, somebody else probably owns the rights to that material. Holding that mindset, I think, is important right there. Once you've gotten that down, then realizing that whatever you find, whatever comes in to your own desktop, if it wasn't created by you, what do you do with it? So using a licensing organization is really useful, because instead of having to do this on every one of your subscriptions, for example, you can know that you've covered all of the digital subscriptions that go to everybody in your organization, so that you can tell them that when they get the subscription, they have permission to do this and not do this. And you can get consistent rules about whether you're allowed to do with a subscription or not. Working with a team, when you're collaborating on something, you don't have time to stop and get the permissions that are required for you to share something that you just found, to share it with other people. That whole idea, the whole concept of that was great in maybe the 1950s or something, but today nobody has time for that. And so the ability to comply with copyright quickly, I think, and continuing a discussion or a good topic is worth more than the waiting, to have to go through the process manually. What a licensing organization can also do is get you permissions to share the document, so that if you want to distribute it, if you want to put it on your website, for example, or if you want to distribute it to all your clients, or to routinely include it in material that you send out to prospective clients. Another thing to keep in mind is that depending on where you work now and where you've worked in the past, you may have had a librarian working within the larger organization, handling some of these things, so that when a subscription started, your organization was already protected because the librarian had organized a license. Many firms don't have in-house librarians anymore, and so often the procurement office or whoever else is doing the purchasing of subscriptions doesn't realize that they need to get permissions for anything else, or that it would be advantageous. And so just because it's coming in doesn't mean it's been cleared, even though it used to be if you worked in an organization that had a librarian in the past. a few of the others, just, things to keep in mind for using any licensing organization. Risk reduction during acquisitions and mergers. If you're acquiring another organization, do you know if they're complying with copyright? Do you know if they have been making sure that the articles that they've been sending out to clients or people on a team have been licensed? If you're considering acquiring or being merged or doing a joint venture with another firm, you want to make sure that you're complying so that that's not a risk consideration on their end. If you wind up collaborating with a non-Canadian firm, do you know if they're complying with their country's copyright requirements? And do you know whether material that you send to them is covered in the permissions that you have with your subscriptions? I think this is particularly important too in making sure that all of your remote workers are complying. It's very difficult to get that message out when you've got, even if it's just one or two people that are working remotely or that have a hybrid work relationship, when they're at home, they need to remember again that anything that they're sending out to someone else they need to make sure that they have the right to do that. And having a licensing organization taking care of the material that's coming into your organization makes all that seamless and frictionless. It's one enormous administrative burden that you don't have to worry about. And honestly, it's often something where the staff is well-meaning. It's either something, it's a rush, or you're doing a favor, or you feel like you have to because the client is asking for this before they can sign a contract. All these things where it feels very urgent and the staff member just thinks, well, this is really important, I just don't have time this time. That's the time when you need to make sure that you've got a backstop here. And instead of counting on everybody stopping and thinking about licensing, having it licensed through an organization means that they don't have to worry about that. Another huge thing, as I've sort of mentioned before, is just cost reduction in terms of direct cost and administrative costs for making sure that you have the rights to redistribute or to save copies of something that you've received. What's really interesting is I do a lot of public speaking to library groups, and when I'm talking about intellectual property and some of the new roles that librarians are taking on, a number of them saying, when I started looking at all the subscriptions within my organization, I realized that we were way oversubscribed. Everybody made sure that they paid for their own subscription for anything. And so they were, belt and suspenders, kind of making sure that they were protected, which was in one sense fabulous, except that what they had really done was only paid for individual subscriptions. So that person that had the subscription still wasn't authorized necessarily to redistribute it to someone else. And they were paying for multiple single copies when they could have licensed access for all of the people within the organization at a lower cost and at more efficiency because they would have been licensed to redistribute it. So that's one time when licensing organizations can sort of say, you can, this is a little bit of overkill to be paying for all of those subscriptions when the single license here will cover you for less cost and more breadth and depth. It also prevents inadvertent repurchase. And so if you have a license to acquire a standard, for example, use it in one project and save it in an internal archive, you've licensed the ability to save that internal copy, then you have it there for reference for someone else later. It's if people are trained to, never reuse an article that we purchased, well, that's okay, but that means that you wind up repaying for it every single time that you use it. And instead licensing it means you pay for it once and you use it multiple times. And the administrative cost in all of this, if you're doing this ad hoc or on just internally without using an organization that does this collectively. There's a lot of overhead involved in managing those licensing and making sure that the right number of people have access to this document, and that, you know, it's being kept within the intranet, but not being all the rules, the terms and conditions that subscription came with. Making sure that that gets complied with is really a burden if you don't have just an overarching license for it. The other thing that I think people sometimes forget is that you can make better, richer, and more and better use of the content that you subscribe to if you get a license for the reuse of it. And so in addition to just being able to use it internally, for example, you can attach those relevant articles to regulatory filings for that you need to send in, or if you're collaborating in a project team that includes people outside your organization. These are especially, this kind of licensing is particularly useful if you are working with or have people working in other countries. And so if you're multinational, or you're dealing with clients that are multinational, where you have to think about what's happening to that document when it leaves your hands, having a copyright licensing organization handle that ensures that you're compliant and you don't have to worry about it. And that's, I think, when you start looking at, you know, moving outside the border of the country, then it starts getting complicated, and no one wants to be a copyright lawyer. Most people don't want to be copyright lawyers. Specifically, why would you use access copyright? And these are things that are fairly straightforward to me. There may also be more specific advantages that, you know, you will find out when you talk to someone directly. But some of the key ones is access copyright is a nonprofit. And what that means is when you're paying money for the rights to use this article, you know that that money is going to the people who created that content. And so you're ensuring that innovation is being encouraged. And that, I think, is that's an important concept, that the money that goes in there, it doesn't just go into a black hole. It's going out to the people that are maintaining, you know, the innovation in the world. Using access copyright lets you make sure that you're doing the right thing, and that you're respecting intellectual property just like you expect other people to respect your intellectual property. It's definitely risk reduction. And I think this is especially the case where whoever is listening to this webinar, you yourself may be mindful of this, but it's hard to get every employee always mindful about never redistributing something that they don't have the right to redistribute. That's a tough thing to keep in front of everybody's mind. Making sure that it's covered through access copyright means that your employees are compliant with copyright law without you having to stress about it. Speed and efficiency, for heaven's sakes, the time involved in chasing down permissions to distribute something on an ad hoc basis is, I don't know, back in the days when you could pay, you know, when there was lots of administrative help and you had clerks that could handle that sort of thing, perhaps that made sense. But in today's age, it makes no sense to have to spend the time for doing something like that. And access copyright lets you get the permissions easily, and not having someone doing all of these little administrative steps. It covers over 100 million published works, which is that's a big number. And what I think is really handy too, especially in a world that is cross-border and you know, multinational, is access copyright has agreements with other copyright collectives in other countries, so that you can make sure that you can get the material licensed wherever you need to make sure that that material is landing or is being used. And that, again, that is the kind of administrative burden you wouldn't want to do yourself. It leverages your content spend, because, as I mentioned before, where some corporate librarians encounter situations where in an effort to be compliant and to make sure that they're covered, organizations will be buying multiple digital subscriptions of the same thing, when they could, for the same amount of money or less, they could get the material distributed to the same amount of people, plus have permission to do more with it so that they can get better use out of their spend. Using excess copyright allows you to collaborate. You can share your material with everybody else in an external group without worrying about getting permission. When you're making a marketing claim and you mention or you footnote an article, you can include those things. You've got the automatic right to do that. You can include them in regulatory filings. And because the licenses, the money that you pay goes to the innovators, goes to the people who've created this content that's useful enough that you want to share it with someone else, that's supporting that whole research community. So you know that the expenses that you're spending are going to, it's not going to a for-profit organization, it's going back out to the people who are being innovative. So I'm going to stop now, and I'd like to take questions and comments. So Peter, I'll let you let me know what we've got.
Thank you, Mary Ellen. As promised, we have been taking questions from our audience throughout today's webinar, but I also want to encourage all of our attendees to take this opportunity to ask any final questions you may have about this presentation, and please be sure to use the Q&A button in the Zoom panel. That's different than the chat one. The Q&A is where we're looking for questions. So one of the first questions which I can answer is, will this presentation be shared as a video afterwards? Yes, as mentioned in my introduction, within about 24 hours after this live webinar today, everybody who has registered for it will receive that archived video copy. Now, in addition, probably about a week from now, we will provide access to the recorded archived video on our website, ccmag.com, under the audio video tab. And how that will work is that anybody who arrives at the website at that point will also register as an attendee. So if anybody you know was not able to register as an attendee in time for today's live webinar, they will have that opportunity. Okay, so my first question now that was submitted for Mary Ellen is, if the copyright holder has passed away, does the next of kin get the rights to the IP? How do they normally pass on?
That would depend on what their estate, who they would assign it to. Their next of kin may not necessarily be it, but it would depend on who in their state inherits their estate, which includes the copyright to that material.
Okay.
And
so very case by case.
Yeah.
The next question is, how can we protect our design or construction drawings from being copied by a third-party consulting firm to be used on their similar projects? Would copyright notes added to each drawing title block help? It
wouldn't hurt. It is inherently, it's copyrighted once it's in a fixed format. So this is simply you can't stop them from doing it. But you could make them feel bad about it when they do. So you can put a copyright notice on the front. If what you see is, you could almost watermark it, just put copyrighted drawing within the drawing itself to make it a little more difficult for them to block it out. But all you can do is put them on notice that what they're doing is a violation of copyright.
And turning things around, if we receive design drawings from a client while the initial designers complete their design scope, and the client is asking our firm to prepare a related design for the same facility, do we have to then ask the client to grant to our firm the original designer's consent before our firm is able to rely on their initial design? That's a great question. And it depends on what, and the second part of that question sort of determines it, is you don't know what the firm's, what rights the firm had in the first place. So this is one of those situations where it completely depends, and in your agreement, you need to specify that
anything that you receive, the other party, affirms that it had the right to give it to you. I think that is probably the best way to do it. But and everyone you have to ask, and it depends. Ask the client each time whether you have permission to do something with this, or whether it was designed by someone else who still owns copyright.
This is a little bit of a fairly broad sounding question. If you're licensing your copyrighted materials to others, what should you consider?
If you're licensing your copy, so you created something and you're giving other people, you're giving redistribution permission to other people. That is my guess.
And I'm assuming this could play into some of the scenarios we just discussed within the engineering field.
Okay. There's the legal considerations and the marketing considerations. So in the marketing considerations, like I write kind of marketing white papers that I put on my website. I write them for other people. That kind of thing. I'm happy to have it redistributed because I like getting it just, it's good for my name. So on those, I would license it with, as long as my name is on it, you just share it as far as you want. If it's something that you have a consideration about, that you don't want it distributed somewhere else, you can specify on that this is not to be photocopied, duplicated, reproduced in any way. Think about, I would recommend just think about the consequences. Is this something that is reasonable for you to limit? Why am I hesitating on that? Is it something, say, for example, if you're sending something to a regulatory agency, you may want to say that this is not to be redistributed at that point. Or if you're sharing it with a group, you can say that this is not to be distributed outside this group. I think I would do worst case scenario on whatever you're licensing, and also keep in mind that you can't stop people from infringing copyright if they're going to. So, figure worst case scenarios. You can't regulate for you can't stop people from doing something, but you can put them on notice that these are the restrictions that you are putting onto the content.
Yeah, I guess the question is sort of, if you were to license your copyrighted materials to others, might that provide some sense of control?
Yes, it could. Again, it won't stop someone, but that's what I do if I'm writing something and making copies for people. I'll always specify who owns the copyright and put in my name and address. And if someone does want to redistribute it after that point, they know to contact to make it easy to get back to me. I guess that's the bottom line, is make it easy for whoever you're distributing it to comply with whatever your requirements are. So if you want to limit distribution, make it clear on the document or what the procedure is for them to make further copies.
Okay. When you have a subscription, can you copy a portion of an article and reference it in your writing?
Yes, you can. The top of my head, I want to say it's 10% is the cutoff. I would say keep it, if it's more than a couple of paragraphs, you probably need to get permission. But yes, you can, if you're doing a review or if you're citing it, you're talking about it, you fully cite it, the footnote points people back to where they can read the original. If it is a small portion where it doesn't diminish anything from the value of that material that the original person created. So if you quote half of an article and say, as so-and-so said, and you put, all of the guts of it in there, you violated copyright because you've essentially copied it in. If you give a teaser of a paragraph and say for the whole article go here, then you're honoring the copyright.
Yeah, that kind of brings up, I guess, the question of where the content is housed. Here's another question that might kind of relate to that. If we receive a technical presentation prepared by an engineering company, may we use it directly without any changes and share it with our coworkers as a learning reference, or is any permission from the engineering company needed?
That's a great question. And the answer is yes, permission is needed. And usually they would be very happy to hear that, but absolutely. And this is just a note that probably applies to a lot of people listening. When I do a presentation or send material or allow it to be copyrighted or to allow it to be recorded, I will say, and you're welcome to share this with other people within your firm, but don't distribute it outside, for example. So I think for when you're on the opposite end of what Peter was just asking about, make it easy for people to comply by specifying what they can do with that material. If you're given it and haven't had that conversation when it was given to you, yes, you have to ask for permission to redistribute it.
And this is maybe a question about some of the wording earlier that you used. I guess it's more sort of just confusion about it. You said if you publish an article, you have to seek permission to distribute the article. Don't the publisher and you have equal copyright of that article? So I guess it's a question of the definition of publisher.
Yes, and of who owns copyright. If I write an article and it is published, if I compose an article and it's published by a publisher, I can assign them the copyright. And so that article, as it was published, they own the copyright for that as it appears. And so if I want to send them a copy of that article, I need to get permission from the publisher to distribute copies. Even though I was the one that wrote the articles, they're the ones that published it in a fixed form. It's the fixed form part that matters. And also how they negotiated copyright. You can sort of assume that usually the publisher owns the copyright for that fixed form of those words, but there are some times when the author retains copyright. So again, this is where having a licensing organization handle this is so much nicer than trying to figure out who owns, whether it's the author or the publisher in this particular journal that owns the copyright.
We had a few questions and comments come out about AI. But as we near the end of the Q&A, I wonder if you could scroll ahead to the last slide, which has the contact details, so that if there are any further questions for Access Copyright after today, those could be sent directly to them, being the sponsor of today's webinar. So this gives everybody a chance to write down that information. So one of the questions came up was, ChatGPT usually provides references. Is that violating copyright? But then there was a reply that said, Bing Chat provides references. I don't think ChatGPT does, at least not the free version. And then there was another comment that ChatGPT and other AI have been reported to provide so-called ghost references and information in general. All information provided by AI needs to be vetted. So it's kind of a couple thoughts there. I wonder if you'd be able to respond.
I'd love to, yes. It's called hallucinating. ChatGPT hallucinates. And so a couple of responses. Yes, when you get sites from a search engine's bot, both Bing and Google have search bots going where it's conversational. When they give you a URL, it is in fact a URL that they have found in their index, and that's a that's legitimate URL. So search engines, search bots are really intended to just massage, instead of getting 10 results on a page, you kind of get the insights from that put together without making you click through all of the pages. That's a super oversimplified way of looking at it. But it's based on, here's the really important thing, is a search engine search bot is based on the material that it found from the websites when it last looked at it. So like its current information. ChatGPT and other sort of standalone generative AI things that are conversational. Number one, they're not necessarily based on current information. ChatGPT is based on information that's as of a couple of years ago, for example. So some of it's outdated. The generative AI systems like ChatGPT, they do make up citations, and you can get them to give you citations, and they make them up And I'm agitated here because just a few weeks ago, I had a marketing consultant send me something from one of his clients who had said, I've done some research in this area already. Here's a few key articles. Could you see what else you could find? So my client just handed it off to me, thinking that this was a very simple thing for Mary Ellen to do. Here, they've even given her the sites. And I spent a good 45 minutes confirming that every one of those citations sounded great. The title was appropriate for the journal that it said it, and they were citing legit real journals. The citation, the URL itself looked familiar with that journal, and yet they were made up. They were similar to other things, but they were all hallucinated. And I had to write a long letter to my client to pass on to his client to explain that just because ChatGPT gave you citations doesn't mean those citations are true. They're similar to other things that are, but you can never take ChatGPT text at its word, because it's predicting, it's generating language based on other language. That's all it does. It doesn't understand what it's writing. It's looking for things that are similar to what it's seen already. Whew, that was a long answer, but it's sort of as far as I can do, a sort of layman's understanding of what it's good for and what it's not good for.
We've had a few late questions also come up during the Q&A. One is, should permission be written, or may it be just orally expressed?
I would never count on orally expressed, no. Although it's great to get on the phone if you get it in verbally and say, I'm just going to send you an email confirming this. Would you just reply yes, please? Make it super easy. It's all be frictionless. And so if you talk to someone on the phone, then send them something immediately, get them just to say yes and go like that. But I would never count on just a phone call or oral at all.
And here's another one. We are members of certain organizations that offer templates for purposes like human relations, HR. The intent is that we can alter these templates to suit our organizations, sometimes quite a bit. Do we need further copyright permission?
You can check with your association. Generally, you have permission to do whatever you want with it. As a member, one of the benefits is that they have licensed this to you for you to use in any way that you want. That is sort of the customary understanding. You can't give that template to someone who's not a member, probably, because it's probably intended only for members. But generally, that's the reason that they give you these templates, is for you to personalize and do whatever you want with.
That makes a lot of sense. Those seem to be all the questions we've received today. So I would like to remind everybody, once again, this webinar has been recorded. You'll receive a copy soon, and it will also be archived for future at our website, future viewing at our website, ccmag.com, under the audio video tab, but that won't be for about another week or so. So everybody who registered in advance for today's webinar definitely has the advanced scoop on it. Thank you all for joining us today. And especially thank you to you, Mary Ellen, and to our sponsor, Access Copyright. Goodbye, everybody.